Welcome. We've just opened up the webinar for attendees. So if you are just joining, bear with us. We will give everyone a chance to get logged in and then we will get started soon. Hello, everyone. As you're joining, I'm Scott Horton. I will be presenting today's webinar on New York Employment Discrimination Update. We will get started soon. Just open this up for everyone to get logged in, so we'll give everyone a chance to do that. As you're joining, you should be able to see the cover slide for the presentation and have access to a chat room. That's where you'll be able to enter questions if you have them that I will answer probably at the end of the presentation, but I encourage everyone to answer or ask questions along the way. And if there's an opportunity to answer them, I will. Otherwise, I will stay on at the end and do it in a question and answer segment. On my end, it looks like everything is working smoothly. So again, hopefully you are hearing me and you can see the slides. The slides will be available after the presentation. At the end, I will provide a link that you can click to download those immediately. Otherwise, everyone who is registered for the webinar will get those by email tomorrow. We'll formally get started in another minute or two, just giving everyone a chance to get logged in if they're able here at the start time. Again, if you're just joining, we'll get started in just a minute. We have a good number of registrants who have logged in, but we still have some who have not. So I just want to give maybe another moment or two to let everyone who is able to get here for the start to get signed in. I know many of you have watched my webinars in the past, and I thank you for returning. If you are new, welcome. Hopefully you will find it both informational and hopefully a little bit interesting. And I also hope that the format works well for everyone. Okay, with that, I'm going to go ahead and launch into my presentation today, give everyone a little bit of overview of how this will work. Again, today's presentation is the New York Employment Discrimination Update, Legal Changes and Practical Impact. My name is Scott Horton. I am founder and attorney with Horton Law based in Orchard Park, New York, just outside of Buffalo. This presentation will focus on New York employment discrimination laws, but will also address some data and trends shown from the federal level through the EEOC. We're very lucky that just yesterday the EEOC released its data from fiscal year 2021, which was the 12-month period ending September 30th of 2021. So as I was finalizing my presentation yesterday, that data became available and I reorganized much of what I was going to present to include some of the highlights from that. I was hopeful that information was going to be available before today's webinar, but you can never be sure with government agencies when they're going to get something out. But fortunately, that worked out for us, and I think that's going to provide some interesting subject matter for really the second half of the presentation. Again, you can ask questions in chat by typing it in. I will answer most of the questions at the end, but I encourage you to type them in as you have them so you don't forget. If I happen to see a question at a point where I can answer it in the course of what I'm discussing, I may do that. The presentation overall will last roughly an hour, and then I will stay on as long as necessary to answer any questions that do come in. Keep in mind as you're asking questions here that this is not a confidential communication because there are other parties. If there is something that you can't ask in a way that you feel comfortable with other people seeing the question and or hearing the answer, then reach out to me separately to do that. And you will receive a link to the slides for today's presentation at the end of the webinar, or if you are registered, you will also get an email following up tomorrow with that information if you're not in a hurry to have it immediately today. Okay, with that being said, here's an overview of what we're going to be going through today. First of all, there have been several amendments to New York law that affect various aspects of employment discrimination law in New York. We'll go through each of those, including a mention of some pending bills that have not yet passed or been signed by the governor, but that may well be on their way to achieving that status. I'm going to talk briefly about the complaint options just to get everyone on the same page as where employees can go to make discrimination claims, with a little bit additional commentary and background on how those forums are proceeding these days. And then, as I mentioned before, we have new data from the EEOC that was just released yesterday. I'm going to give some highlights of that to give a little bit of an idea of what we're experiencing over the last several years and the last year in particular, as maybe that will be helpful to know what to expect or just sort of where we are trending. And that includes a little bit of information specific to New York, but most of that data is nationwide. Finally, we will discuss some of the specific requirements on employers in New York with respect to harassment and discrimination, as well as some of the additional measures that can be taken and often are recommended to try to further prevent discrimination and harassment, or at least to reduce the potential liability therefore. Okay, so there are really, I think there were three bills that have been recently signed by Governor Hochul that cover, in my review, four different topics. So one of them doubles up on the items here. It's really a separate issue. So these different items include the coverage of government entities under the New York Human Rights Law, which is the law in New York that prohibits employment discrimination, among other things. There is a new specified form of employment retaliation regarding personnel records, which is kind of interesting. There has been an additional extension of power to the New York Attorney General to allow the Attorney General to initiate suits of retaliation in the workplace. We'll talk about that. And then finally, the legislature, with gubernatorial approval, has required the New York State Division of Human Rights to create a sexual harassment complaint hotline, or sexual harassment complaint assistance hotline. And we'll talk about what that will mean or might mean. So, first, if you happen to be a governmental entity, this might be relevant to you. If not, it might just be relevant to you as a general matter. So, the New York human rights law now generally prohibits all employers within the state from engaging in employment discrimination. There used to be a 4 employee threshold for that coverage, but by and large, now every New York employer is covered in some respect under the human rights law. The gap that the legislature has sought to fill here involves some cases where employees of the judiciary or of certain elected officials were trying to pursue harassment or employment discrimination complaints against the state or a local government entity, and the court were not so convinced that in that case the state or the government subdivision, a municipality or public authority was itself the employer of the person alleging harassment. So this language has been added to the definition of employer in the human rights law, saying that the state of New York shall be considered an employer of any employee or official, including any elected official of the New York State executive, legislature, or judiciary, including persons serving in any judiciary capacity and persons serving on the staff of any elected official in New York State. So this is really just making sure that the state itself can be brought in as a party and could be held liable or otherwise responsible for harassment and discrimination that occurs, even if, for example, by a judge or an elected official in some other capacity. And there's a companion provision that applies the same principle for municipalities and other government entities at lower levels than the state. A second item that was brought in with the recent legislation is this personnel records retaliation. In relatively simple terms, what this does is specifies that among the various unnamed actions that constitute retaliation against someone who has raised a claim of discrimination or otherwise participated in some process to attempt to resolve claims of discrimination, you, or I should say, employers now may not disclose an employee's personnel file because that person engaged in some sort of protected activity with respect to the employment discrimination laws. There is a limited exception for disclosure required in legal proceedings. So, obviously, if an employee sues the employer claiming harassment, and as part of discovery in the case, they request the personnel file, then the employer may turn over the personnel file without violating this new retaliation provision. This obviously relates to some situations where individuals have claimed that they were harassed or discriminated against, and the employer, through some agent or another, whether expressly or by some form of leak, has identified information in the employee's personnel files to attempt to discredit in some way the claims made by this employee. So, this provision will certainly deter employers from engaging in that activity going forward. And if they do it, it may result in a separate retaliation claim. There is some reason to be concerned that this provision could be interpreted over broadly to essentially tie any employer's hands in their attempt to rebut claims by employees outside of court. In other words, it could certainly come into play in the situation where a company is asked to provide a reference for a former employee who has filed a claim against that company, arguably even providing dates of employment, for example, could constitute disclosing personnel files, as it's not entirely clear how far that term will be interpreted. But certainly any documents that would be put forth an effort to show that the person's claims are not accurate would seemingly violate this provision. That same piece of legislation added Attorney General authority to sue employers for workplace retaliation. That's not limited to the personnel file retaliation that was just created in the same law. So anytime the New York Attorney General thinks that an employer either has retaliated or is about to retaliate against an employee who has engaged in some form of protected activity vis-a-vis employment discrimination, the Attorney General now can go into state court and seek relief. This is expressly in addition to existing rights of employees to pursue their own claims. So obviously, most of these cases historically come up because the employee has gone somewhere and made a claim of workplace retaliation that has then been adjudicated in the applicable procedure. But here, the Attorney General is given the right to do it, apparently, even whether or not the employee wants to pursue such a claim. And there's at least a possible question of whether the Attorney General could file such a suit, even where the employee has already settled with the employer. There are possible legal arguments and defenses to that, but those remain to be tested under these new provisions of the human rights law. With that being, one second. So apparently I left out the slide that meant to address the new hotline being created by these bills that will require the New York Division of Human Rights to establish a phone number that employees can call to ask for assistance in determining whether they have a claim. Oh, I do have that. It just got out of place. I'm sorry. Let me hop ahead. Okay, so here it is. So beginning July 14th, if not sooner, there will be a phone number. The law specifies that employers will need to include that information in the materials that they're required otherwise by law to disseminate. This likely will mean both the employee right posting that is required with respect to the human rights law and policies, primarily here meaning, of course, the sexual harassment policy that all New York employers are now required to have. You're already required in that policy to identify places that employees can go to make a complaint of sexual harassment, which includes the New York State Division of Human Rights. So this will be a new hotline, exactly how they implement it, whether they're going to use their existing number or create another one, remains to be seen. The other important aspect of this is the law says that this is designed to connect employees to pro bono attorneys experienced in sexual harassment matters. There was a previous draft of this legislation that I think made it even more specific, that there would basically be attorneys answering the phone. And it certainly doesn't seem like they mean just attorneys working for the Division of Human Rights, because it references pro bono. The prior draft talked about establishing a panel based on efforts to work with bar associations, etc. Um, Interestingly, the statute as enacted goes on to discuss that the attorneys who work with this hotline and talk to these potential complainants may not solicit those employees to represent them in their cases, or at least not for money. So it certainly raises a question in my mind as to where they're going to find the attorneys, who they're going to be, and how they're going to encourage enough of them to be available to assist the people that are going to call this hotline, given that the attorneys would then be precluded from receiving any compensation for representing these individuals in sexual harassment cases. The most likely outcome, I think, is what the current most likely outcome is, and that would be that someone who calls this hotline, just like anyone else who calls the Division of Human Rights now, will ultimately be advised that they can file a complaint with the Division of Human Rights. So, in that sense, I'm not entirely sure how this changes things unless these attorneys are going to actually spend time in effectively coaching the employees in how to best make their claim, to best assert the wrongs that they allege they have suffered. And whether these attorneys are going to be motivated to go that far really just remains to be seen. Now, there is a interesting potential loophole going both ways in this bill, and that is that it doesn't say anything one way or the other about any of the other forms of discrimination. It is limited to sexual harassment. So, does that mean that an individual who calls this hotline will only be able to discuss sexual harassment concerns? Will they be shut down if they try to say that it was also um, they also experienced some race-based harassment or discrimination because they were a woman, or any of the other things that someone could normally raise under the human rights law or with the Division of Human Rights? It seems unlikely to me that these attorneys would just shut them down entirely and say, I can only discuss sexual harassment concerns. But again, that is what the statute addresses. And then the flip side of that is that the statute says that these attorneys have to work pro bono and can't solicit for any sexual harassment claims, but doesn't really address whether they could then attempt to represent the employees that call for pay with respect to claims of something other than sexual harassment. So, in reading this legislation, those are some of the questions in my mind. I think this is going to be very interesting to see how this plays out. As a practical matter, at this point, I'm assuming that it's just going to mean that people are going to call the Division of Human Rights, whatever number that might be, and eventually they're going to, more often than not, just file a complaint with the Division of Human Rights. Okay, sorry. So somehow my Slides got a little bit out of order. We'll get back on track. Okay, so that is the 4 items that were recently passed and signed off on affecting New York employers. There are several other pieces of legislation currently pending. All the ones I'm about to discuss have passed the New York Senate, but have not yet been voted on in the Assembly. So there's certainly reason to believe that these could become law at any point, but they just have not gotten there yet. So one of these bills would eliminate any potential penalty for employees violating non-disclosure or non-disparagement clauses of release agreements covering any employment discrimination claims. Breaking that down, what does it mean? It is certainly common, and some of you will be familiar with, that when you have a severance package or a settlement of an asserted employment discrimination claim, that you include a non-disclosure and or non-disparagement clause with the idea of keeping the employee from nonetheless going on to make allegations. Even though they couldn't then file a lawsuit, they could still publicly claim that the company did something inappropriate and or that they were paid to go away, for example. The law was changed a couple of years ago to make it a little harder to get a non-disclosure agreement in these types of settlements, but it is possible still. This bill would basically seem to say that even if you get that clause and go through the right procedures to have it in your document, you can't include a penalty for a violation. In other words, you can't say if the employee violates this provision, they will have to pay the company X amount, or the legislation also says they can't then be required to forfeit anything that they received in exchange for signing the agreement, which kind of begs the question of what's left. What's the mechanism of enforcing such a provision? And it's certainly at least arguable that there is none, and that there would essentially be no actual teeth in such a provision. It would just serve as some sort of suggestion on paper to the employee that they shouldn't be talking about this. I suppose the law might arguably still allow the employer to file a lawsuit against the employee and somehow demonstrate that the company has suffered damages as a result of the disclosure that violates the agreement, but any damages in that situation would be speculative and potentially hard to calculate, and whether there'd be an effective way to recover them from an individual employee would also remain open for question. A second piece of pending legislation would ban no rehire clauses. So again, in these same types of agreements, the employer often anticipates the risk that they settle with a former or separating employee, and then the employee will just come back and apply for another position. And then when the company doesn't rehire them, say that they have been retaliated against because they previously alleged discrimination. There's generally a belief that you can't prospectively waive such a claim in a release agreement, but it has been the practice to therefore specify that the employee will not seek or is not eligible for future employment with the company or the employer, whatever it might be. The proposed legislation would specifically ban such efforts or provisions in releases of employment discrimination claims. Again, whether that passes and is signed by the governor remains to be seen, but at this point I can't really point to any specific reason why I would doubt that it will become law. And a third piece of proposed legislation is a two-part one in essence, but it basically extends the time to file employment discrimination claims. It would extend from, in most cases, a 1-year period to file with the Division of Human Rights to 3 years, which is currently the standard for sexual harassment claims. And it would allow any employment discrimination claims under the New York human rights law to be filed within 6 years directly into court. And that's an extension from 3 years. So that would just give employees more time to decide to make a claim against their employer. Again, none of these seems obviously unlikely to succeed, but they were not enacted along with those several other items that I discussed before that are now law in New York. So it remains to be seen for sure when and whether these will take effect. So we've kind of alluded to some of this and what I just mentioned, but I want to talk about it in a little bit more detail. So there are several options for filing employment discrimination claims in New York. One, of course, is just the internal complaint. So an employee can certainly go to their employer and say that they believe they are being harassed or discriminated against. That doesn't afford the employee any particular remedy, other than it does potentially enable them to make a retaliation claim down the road if they feel that after filing that internal complaint, they have suffered some negative consequences, which would now include releasing their personnel file, for example. More typically includes, a subsequent demotion or termination from employment. The next sort of level of complaint would be with a government agency. I say most often, at least throughout most of New York State, this would mean the New York State Division of Human Rights, where it's relatively easy to file a complaint, even without that hotline that we were just discussing. Any employee can contact the Division of Human Rights, say that they have suffered some form of employment discrimination. They will then be given a form to fill out with check boxes. Which categories of discrimination do you feel you have suffered? And then explain. And then that will start a process where the Division of Human Rights begins an investigation and potentially will hold a hearing with one of its own administrative law judges where the employee doesn't need to be represented by an attorney. The Division of Human Rights, if it gets to that stage, will essentially provide an attorney to marshal the employee's case for them. So that, for various reasons, is, like I said, probably the most likely external source of complaint in New York State. The one potential exception to that would be in New York City, where there's a local agency that effectively does the same thing, the New York City Commission on Human Rights. So if you are present in New York City, then you may likely be familiar with that agency. Technically, there are other local agencies around the state, but they are very seldom relied upon by complainants. I honestly had a case once a while back where there was a complaint filed with a particular county level human rights agency, and it seemed like it was probably their first case in some number of years, and they had to figure out what they were supposed to do. They then did eventually do basically the same thing that the Division of Human Rights does. And finally, there is the EEOC, which is the federal agency that has jurisdiction over the federal employment discrimination laws throughout the country, including New York State. Employees in New York can file directly with the EEOC. They can also file with the New York State Division of Human Rights and cross-file with the EEOC. That's important because it preserves their ability to pursue claims in court under the federal employment discrimination laws. At this stage, it's not clear that it's often critical for employees to preserve those rights because the New York human rights law is almost always as favorable or more favorable as far as the standards and remedies available to employees. In the past, there was some greater cause to preserve those federal rights because you could get, for example, attorney's fees under the federal discrimination laws that you couldn't get under state law, but recent amendments to state law have added that at the state level. But we do nonetheless still see some cases filed with the EEOC in New York. They do not have the same procedure as the Human Rights Division in the sense that they will investigate the cases, but almost invariably, with some exceptions we'll talk about in a few minutes, they will then dismiss the case, giving the employee the right to sue on their own behalf in court, which basically is distinguishable from the Division of Human Rights in the sense that you have to actually end up in court to, have your case adjudicated, and also in that there's then no attorney provided by the EEOC to pursue the claim on the employee's behalf. We've mentioned obviously multiple times going to court. You can do so, an employee anyway, can do so directly under the human rights law. In most cases, under the federal discrimination laws, Title VII, the ADA, the Americans with Disabilities Act, the ADEA, the Age Discrimination and Employment Act, GINA, the Genetic Information Non-Discrimination Act, and the Federal Equal Pay Act are all statutes the EEOC oversees. So if you want to pursue those claims, you usually have to file with the EEOC first. You do not have to do that under state law. Employees have the option of either going to the Division of Human Rights or going to court. Typically, once you go to the Division of Human Rights, you can't then get a second bite of the apple at court. Employees can challenge, as can employers, in fact, challenge the outcome of a hearing at the Division of Human Rights or an investigative no probable cause finding. But once you get your final outcome from the Division of Human Rights or challenge that outcome, you can't separately ask a court to adjudicate the merits of those cases. Finally, I list arbitration here in relevant respect to another legislative change, actually one that recently occurred at the federal level, but has particular implications in New York. So usually by default, arbitration wouldn't be an available option for any of these claims. There's no law that generally says if an employee wants to go to arbitration over an employment discrimination claim, then they can. But many employers have historically required their employees to sign an arbitration agreement or have an arbitration provision in employment agreements, for example, that at the time of hiring, the employee must sign as a condition of working for that company that says if you develop any claims while you're working for the company, then you can't file them in court. You have to go to arbitration. This typically wouldn't prohibit anyone from filing with the EEOC or the Division of Human Rights, but it would basically select arbitration as the alternative to court adjudication. Among the perceived advantages to this would be that arbitrations can be kept private, where court proceedings are generally open to the public. And there can be other procedural differences between courts and arbitrations that some may prefer. This has raised some controversy in recent years as to whether companies should be able to force employee claimants into private arbitration rather than public court proceedings. And New York passed some laws in the last few years limiting such pre-dispute arbitration agreements regarding employment discrimination claims, first for sexual harassment claims and then for all employment discrimination claims. These have not fared very well in the state courts because there has been federal law that the Federal Arbitration Act encourages arbitration of disputes. So courts have typically in New York said that these laws in New York seeking to prohibit arbitration are not enforceable. Before I go on to the latest development in that area, I just want to throw something out there for everyone. This is anonymous, but just out of curiosity, does your organization require employees to sign arbitration agreements as a condition of employment? Just interested to see how prevalent that practice is amongst this audience. So, as some additional responses are coming in, the yes percentage is going down, the no percentage is going up, but it's looking like maybe about 20% of you say your organization does have an arbitration agreement. Most of you, then 75%, do not. That without knowing what the actual average number across New York State would be, that split doesn't surprise me. I would say the minority of organizations overall have these arbitration agreements, but it's certainly not a rare requirement. So, going back to what we were just talking about recently, President Biden signed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. This piece of legislation, I don't necessarily want to say surprisingly slipped through, but was a relatively rare bipartisan piece of legislation that got to the president's desk these days, and he obviously signed it. What this law does is invalidate these types of pre-dispute arbitration agreements with respect to sexual assault and sexual harassment claims. So, especially in the workplace, the sexual harassment claims under Title VII and or under state laws like the New York Human Rights Law now are not subject to pre-dispute arbitration agreements. In other words, if you have the employee say any disputes arising during employment will be subject to arbitration, that could not be enforced as to sexual harassment claims. It likely could still be enforced as to any other types of claims. And it's not clear that you have to specifically carve out sexual harassment claims when you write those arbitration agreements, but clearly, as an amendment to the Federal Arbitration Act, this law is now going to give employees the right not to arbitrate their sexual harassment claims. Of course, if they want to agree to do so, they certainly may, but they can't be compelled to do so. It does not address any other forms of employment discrimination, including just sex-based discrimination. For example, someone claiming that they were not hired and a male was hired and they feel that that was a sex-based decision, that would not be prohibited from arbitration. Now, in that case, if someone wasn't hired, they may not have signed such an arbitration agreement, but let's say it was more like a promotion situation, then that could be an issue. Now, if you remember, I mentioned that New York had anti-arbitration statutes that the courts have not most often enforced. This seems likely to affect the enforcement potentially in two ways. One, it is now clear that you're not going to be able to enforce these provisions in sexual harassment cases. But as to other forms of employment discrimination, I think this may only strengthen the argument that New York's law can't prohibit enforcement of arbitration agreements outside of sexual harassment claims, because the carve out at the federal level is clearly specific to sexual harassment claims, in effect indicating that it's still clearly the federal law that any non-sexual harassment claims can be subject to pre-dispute arbitration agreements, and as federal law that preempts the New York state laws. So I'm not a judge and I can't guarantee that that's going to be the outcome, but that is what I predict this will mean in New York at this point. Whether in the future Congress extends this ban beyond sexual harassment to other forms of employment discrimination, I can't say, but that remains a possibility and we will just have to wait and see. All right, so that is really the legislative development portion of the presentation, which was obviously most of the hour. But as I mentioned yesterday, the EEOC issued its annual performance report and its annual charge data. So I reviewed that and wanted to share some of the highlights that may affect what employers across the country will start to see or have been seeing and may continue to see regarding discrimination claims. The EEOC, again, is the federal agency, so this does not specifically talk about the New York State Division of Human Rights or New York City Commission on Human Rights. They're not one and the same, of course, but both are relevant in New York, and the EEOC nationwide reported that they filled 450 or more positions in the last fiscal year. So again, that was October 1st of 2020 through September 30th of 2021. That brought their staff up to 2,100 plus employees. Some of those 450 positions were filling positions that had been vacated within that fiscal year, but they have identified that basically that brought them from 1,900 to over 2,100 employees from fiscal year 20 to fiscal year 2021. So it is an increase in employees. Interestingly, there was a note that in 1980, the EEOC had 3,300 employees. So they are way down. Of course, since 1980, many things have changed, including technology and that type of thing, to where maybe some of the change in overall staff doesn't reflect anything other than the changing times and the relative efficiency of one worker versus another. But I just thought that was an interesting note. Probably more important than those numbers is the identification by the EEOC that the people being hired are primarily on the front line, which they say means investigators, mediators, and attorneys. This is reasonably interpreted as some identification that they are becoming more active in trying to, whether it investigate cases or get them resolved or litigating them, but doing something actual case management wise, rather than the types of positions that would just set policies or write guidelines and engage in sort of outreach measures. So, one could interpret this to say the EEOC wants to prosecute more cases more extensively, um, or one could interpret it differently, but there's something implied by the fact that the EEOC identified that specifically in the report. In this last fiscal year, the EEOC says it filed 116 lawsuits, which was up from 93 in the previous year. So that's not an insignificant percentage increase. Overall, the point here is that 116 lawsuits is not that many. So when a charge gets filed with the EEOC, as I said before, most often they don't resolve it on the merits through any sort of adjudicatory process. Most often they're going to dismiss the case, which doesn't necessarily mean the case doesn't have any merit. It just means that they don't file lawsuits very often based on the charges they receive, and the employee is on their own to pursue any claim they feel they still have. But when the case warrants, when they feel that there is clear, persistent discrimination or discrimination involving large numbers of employees, called systemic discrimination, then they will file lawsuits. And in the past fiscal year, they did do so more often. And one other numerical note from the annual performance report is that the EEOC identified that it obtained $485 million for victims of discrimination, but that is actually down from $553 million in the previous fiscal year. Now, before I go on, the EEOC itself is led by a 5-member board in Washington, and there is reason to believe that the EEOC is trending towards more aggressive enforcement of the employment discrimination statutes, given that President Biden, as a Democrat, which tends to be more pro-employee party, is now in power. The board itself has a chair and vice chair who are Democratic appointees put in those positions by President Biden. However, because the EEOC has fixed terms for its members, the other 3 members are still Republican members who were appointed by President Trump. So at the top policy level, the EEOC currently still has a majority of Republican members, which has likely held them up from being as aggressive as one would expect under this administration. The next expiration for a board member is a Republican member with her term expiring July 1st, at which point in time you can fairly assume that the president will appoint a Democrat, which will shift the policy perspective at the EEOC. So that is some reason to believe that the numbers we see from the last fiscal year will look different in the next fiscal year, because the people setting the policy at the top have a different view of enforcement. So it's helpful to look at the charges filed at the EEOC rather than just the lawsuits that they file. They file 100 and some lawsuits a year. As you see, though, as you're going to see, there are usually tens of thousands of charges filed in a year. So again, a very small percentage of the EEOC ends up prosecuting. Usually it's up to individuals. The interesting thing about the fiscal year 2021 data is that charges were way down. Again, a little bit unexpected in a shift from a Republican to Democratic administration, on the theory that employees may feel that they're going to be better received by what's thought of as a more employee-friendly regime. Separating out the politics, that seems to be the general view. The cases were down 9%. What I think is most likely responsible for that decrease is that COVID-19 probably created fewer opportunities for someone to either feel discriminated against or to feel that they needed to make a case with the EEOC. We can see that 6% of the charges that were filed alleged discrimination related to COVID-19. Obviously, that 6% of cases would have been zero a couple of years earlier. The cases alleging discrimination related to COVID-19 aren't further broken out by the EEOC, so we don't know whether these are all like disability discrimination cases, either people saying that they were discriminated against because they had medical reasons they couldn't get a vaccine where the employer was requiring one, or because they were fired after missing work due to COVID-19, or if this also includes cases where employees were terminated just due to workplace closings or reductions in force because of general impact of the pandemic. So I'm not exactly sure, but I think overall there's reason to believe there's fewer charges because of the COVID-19 pandemic. I mean, there are other possible interpretations such that less employment discrimination occurred than in the previous year. I think that is actually possible. But again, to the extent that's the case, one would wonder how much of that is just because people working from home or the increase in demand for workers has overall affected the workplace rather than just some belief that suddenly people have become less likely to engage in employment discrimination or harassment, which of course would be the best case scenario. I mean, that would be great if that's true. But there's not, as much evidence that that's what's going on. Most categories were affected equally by the decline. So again, the EEOC has various laws that it enforces and prohibits discrimination based on age, sex, race, color, national origin, religion, disability, a host of different categories. Overall, most categories declined roughly consistent with the overall decline in cases. Sexual harassment charges in particular were now at the lowest level in over 25 years. So the data the EEOC has available goes back to 1997, and sexual harassment charges filed in fiscal year 2021 were the lowest on record in that 25-year period. So here is the annual charges over the last 5 years. Back in fiscal year 2017, there were 84,000 charges. Last year, there were 61,000 charges. So that is a pretty significant reduction of about 25% in 5 years. So again, I said they were down a lot last year and said that COVID might have been the result of that. It's impossible to say just based on the data that's available because there has been a continuing decline over the past several years. One might attribute that again to a Republican administration having been in the White House. I've analyzed this data going back further, and it's kind of hard to show that the administration actually determines the relative trend in charges filed, but that could be one explanation for the decline leading up to last year. All I can ever say on this is it will be interesting to see what the numbers look like next year and see if we can determine anything based on that. Looking at some of the specific categories, recognizing, like I said, most of them are down equally. Sexual harassment, as I said, is at the lowest level on record. There was a peak in 2018. That was the height, or at least the launch of the Me Too movement. So we did see a spike there, disproportionate with the overall charges, which were going down. But that has, fallen back again beyond the lowest levels we've seen in this data. The sexual harassment charges are the one area where the EEOC provides state level data. So this is the one situation where they include both charges filed with the EEOC and with state agencies. So in this case, the New York State Division of Human Rights. I don't know whether that data is as good as their normal data on the EEOC charges, but again, charges with the state agencies are usually cross-filed with the EEOC. So this is what we have for New York. Again, this pretty nearly matches the trend at the EEOC. However, last year's drop off to 307 cases is a little bit higher than what the drop off percentage wise was at the federal level. So, guess what that means. I think it may also still relate to the COVID issue that I was talking about, on the theory that New York had some of the most, or the strictest COVID restrictions, and probably fewer people actually in the workplace, which, if a positive side effect of that could have been that there were fewer opportunities for sexual harassment to occur. Not that they couldn't occur remotely, but that's just a hypothesis, but something to consider. Here, just a couple areas where the EEOC charges did not decline. One is LGBTQ plus based sex discrimination. This is a category that the EEOC has only been tracking for the last several years, largely because before recently there was really no cause of action under the federal employment discrimination statutes related to these issues. Sex-based discrimination charges were usually dismissed if they were based on, one's sexual orientation. But a Supreme Court decision relatively recently changed that, making it easier or more likely that the federal employment discrimination laws could be violated based on sexual orientation discrimination. So that may explain the slight increase here, although the increase from fiscal year 20 to 21, is a pretty noticeable bump. It could easily be explained by that change in the law. One other thing, and then we're just going to get into the last couple wrap-up slides and answer your questions. The race discrimination charges at the EEOC have gone down, consistent with overall decline in charges, as you see here. But color discrimination charges have gone up a little, or at least been relatively steady. Here, I would hypothesize that this is not directly related to any change in the law. It's probably just more an increased likelihood that employee alleges not only a race-based discrimination claim, but also a color-based discrimination claim. There are separate categories in Title VII for race and color discrimination. Historically, they've probably been looked at as more or less interchangeable, but I think there is a greater recognition today of color-based discrimination, even independent of race-based discrimination. So 2 African-American employees, for example, who have different skin tones, if one is favored over the other, that could give rise to a color discrimination claim. And of course, that same could be true in other, ethnic or national origin types of groups. So Keep in mind, these charges can overlap. You can have a race discrimination claim, a color discrimination claim, a national origin discrimination claim, among others. But I did think that it was interesting in the data that with the overall decline in other categories, there has been a slight uptick in color discrimination claims. Okay, so with that overview, I'm going to wrap this up. That overview of the data, I'm going to wrap this up. What are your requirements as a New York employer? You must have a sexual harassment policy under New York law. You must provide annual sexual harassment training under New York law. And there are the employee rights postings that you must put up under both state and federal law. So with that being said, what else do employers do to try to avoid harassment, discrimination, and liability therefore? Many employers have, it's probably a best practice to have an EEO and more general anti-harassment policy. So don't just have a sexual harassment policy, have a policy prohibiting harassment based on all forms of protected categories, and have a policy saying that you will not discriminate based on any protected characteristics. These are relatively standard, but not everyone has them, especially smaller employees or employers. If you are a federal contractor and are subject to affirmative action guidelines, you may have these as required policies. But for the most part, they're not specifically required. They're just universally recognized to be advisable. Many employers will also have written reasonable accommodation policies and or procedures. This obviously relates to disability discrimination issues. And then the next couple of items are probably the biggest differentiators. The New York State requirement of sexual harassment training every year may have had some impact on general anti-harassment training and the frequency that employers provide that. So sexual harassment is just one form of legally prescribed inappropriate workplace conduct. It's certainly not a bad idea to do anti-harassment training that encompasses other protected characteristics. So if that is something that you haven't done as much because you have to focus on the annual sexual harassment training, that might be something to consider. The other form of training that is certainly worth considering is general management training. So whether specific to harassment or discrimination or not, is likely that training of how to be an effective manager will play some role in how likely it is that harassment or discrimination take place or are permitted to continue within a workplace. Or frankly, if nothing else, employees with better managers are probably less likely to pursue claims of harassment or discrimination on average. With all this being said, I don't know that it's possible for any employer to prevent all forms of harassment and discrimination from taking place in their workplace. The laws that are being passed in Albany seem to be largely premised on the theory that sexual harassment can be prevented by employers. Certainly some of it can be, and it can be put to rest sooner rather than later in some cases, but there's a pretty strict liability measure underlying what the legislature in New York is doing with these changes to employment discrimination law. And it may not be possible for employers to protect themselves from all liability. But liability can be costly, both monetarily and reputationally. So there's reason to take any of these measures within reason within your workplace, recognizing that by taking these measures, you are not going to eliminate all harassment and discrimination with 100% certainty, but at least you're going to hopefully reduce it and have a better story to tell in defense of a claim that you do receive. So now I'm going to put up the link for the slides and I'm going to go through the questions. If you have more questions, type them in. I know there's some here and I'm going to start answering those. If you want our latest updates, I suggest you follow Horton Law on LinkedIn. We have a monthly email newsletter that goes out as well. We try to limit that for only the monthly dissemination plus anything that's super critical, but we more often post on LinkedIn as soon as we find out some new information that may be relevant. So there should be coming up the link to the slides so you can get those, and then I will start answering the questions that have come in. So there's a question, how is it considered retaliation if the employee's attorney or other entity requests the personnel file? I mean, it's a new law. It's not very specific in a lot of respects, so we don't know all the answers yet. I mean, to be retaliation, theoretically, it would still have to have been done because the person filed a complaint or otherwise engaged in some protected activity. So if you just have an employee who's never, as far as you know, raised any concern about harassment or whatever, and there's some reason to turn over their personnel file, then there shouldn't necessarily be a problem of that being retaliatory. I mean, the aim is more of a situation where someone has alleged discrimination or harassment, and now the employer is trying to release that information to discredit the claim. But the potential interpretation of the statute is broad. So if somebody has made such a claim and their attorney asks for the file, I would probably at least go through the effort of making sure you have some evidence that the employee or person whose personnel records it is has asked that information be provided to that attorney or other entity. But there are open questions for sure on the interpretation. There's a question generally about personnel files. Was a good question for a couple of reasons. So under what circumstances can an employer when can an employer refuse to release a personnel file? Let's put it that way. And there's reference to subpoenas. So yeah, generally the theory in New York is that the personnel file is the employer's property and they can do with it what they want, other than now they can't release it in a retaliatory manner. There is no law in New York that requires the employee to have access to their personnel file. Some collective bargaining agreements might have that type of requirement in it, but as a legal matter, it's not currently required as it is in certain other states. So if you get a request, whether it be from the employee's attorney, or anyone else that says, I want the personnel file of such and such, even if the employee has authorized it, there's generally no obligation at that point to provide it. Once you get a subpoena from a lawyer or a judge saying that you are required to provide the personnel file, then you can scrutinize whether the subpoena itself is proper, and you could potentially go to court to try to quash the subpoena and not provide the document. But a valid subpoena does create the obligation to disclose that record, just as it would any other document. The flip side of that, and the reason I said it was a good question for a couple of reasons, is there is pending legislation in New York and has been for a number of years that would require employers to make the personnel files available to employees or former employees under various circumstances. I think there may actually be multiple proposed bills that address it a little differently. Again, to date, none of that has become law, but it will not surprise me if and when it does. So stay tuned. It's a good question about what's the typical timeline between an initial EEOC claim and resolution. So nothing is typical, especially these days. The best answer to that question is obviously it depends. It can depend on how extensive the claim is, whether there are multiple employees who are alleged to have suffered from the same form of discrimination, or if it's a single employee situation. But and it can also depend on where you are. So there's an EEOC office in Buffalo, there's EEOC offices in New York City. There are, I think they closed the Rochester office. I'm not sure on that one at the moment. And there are EEOC offices throughout the country. At times in New York, we have seen investigators from outside of New York handling cases that were filed in New York. They are not opposed to shifting around the workload to where they have employees more readily available. Certainly, part of the reason they're hiring new employees is an attempt to reduce the amount of time it takes to resolve a case. And with that being said, from initial complaint to dismissal, which is the most likely outcome in most cases, I mean, you're certainly talking months, but in some cases, you're talking years. There are opportunities for the employee to contact the EEOC and say, would you please give me my right to sue letter because I want to go file in court? But A, employees don't necessarily know that. B, employees aren't necessarily planning to go to court, so they don't want to pursue that. But if they are represented by an attorney, that's not unheard of, that they will just ask for their right to sue letter. But on the other hand, their time to file that claim under federal law does not start running until they get that right to sue letter from the EEOC. So they're not, in that sense, necessarily deterred by having to wait to get the letter. The Division of Human Rights is similar, except they can handle the case internally. So again, probable cause or no probable cause letter is the first step in the Division of Human Rights. After their investigation, again, you're talking months, possibly years before that happens, depending on circumstances. And then once you get a probable cause finding, the next formal step is a pre-hearing settlement conference, which probably comes months later. And then after that, you would get, if it doesn't settle, you would get a notice of hearing before a Division of Human Rights administrative law judge. And again, you're talking months, possibly years before that happens. I think if you had a case go to pre-hearing settlement conference today, it's likely that the case would not be heard until at least sometime in 2023. If an employee claims hostile environment, is this basis for filing discrimination charges? So a hostile work environment is a legal term, really, as a form of workplace harassment. But as a condition of making a claim under any of the state or federal employment discrimination laws, the person will ultimately have to identify a protected category. If it's just a hostile at work environment because their boss or coworkers don't like them, then that's not a discrimination case. If they say that it's a hostile work environment because their boss or coworkers don't like them because of their race, age, gender, sex, sexual orientation, religion, etc., then it could be the basis for a discrimination charge. So that's about as carefully as I can answer that question. I mean, depends on what they allege specifically or what you think they're alleging. But if it becomes clear that they're not referring to any protected category, then yeah, right now there's not a cause of action under the employment discrimination laws. Again, New York has pending legislation, as it often has in the past, and certainly won't shock me if and when it passes, that would effectively implement a workplace bullying statute where there would basically not be any protected characteristic requirement, and then a hostile work environment claim would basically be anytime the employee feels they were somehow unfairly treated negatively. And what the standard there would be depends on what the law that might eventually get passed says. But that's really where we are, is the distinction between employment discrimination and bullying. And right now, bullying per se is not necessarily illegal, where employment discrimination, if it's based on a protected characteristic and otherwise meets the standards, would be. Okay, so I see a question. Let's see. Had an employee who was a great worker. He complained about another employee, did not like the response from managers, and persisted for a response. Other employees began to complain, saying they didn't feel safe, and he was let go. He's now filed for unlawful termination and retaliation. One of the managers stated in response. Yeah, so I know you got cut off. Feel free to go ahead and type in the rest of what you were going to say. I will wait and look to answer that. But I will start to address that a little bit, piggybacking on what I was just saying about hostile work environment. So if the employee complained about employment discrimination, including harassment based on a protected characteristic, and then was terminated, then perhaps there are employment discrimination claims and retaliation claims to be had. If it was clear that the complaint was just, my manager favored another employee and not based on any protected characteristic, but say because they were friends or whatever, then there wouldn't necessarily be the basis for a wrongful termination or retaliation complaint. So based on what you had gotten typed in, that's the best answer I can give at this point. But here we go. They said he was he was operating in an altered reality. Did she give him more fuel by attacking his mental state? Well, I mean, arguably, depending again on what the claims were. Yeah, I mean, I think the facts of that case would have I'd need more detail to really address it, but I guess the basic conclusion I could say is yes, if you said somebody was operating in altered reality, at the very least, somebody could argue that that's a perceived disability under the ADA or the human rights law, which might give some protections. But again, the timeline and exactly what was alleged when and whatever could be relevant. I think I've addressed all the questions that I got that I can. There's a question about someone wondering whether they've been discriminating, and I can't answer that here. It's too specific to your specific situation, and my firm represents employers, so we would not be able to represent an employee with a discrimination claim. So just to address that, I will be happy to hang on for a minute or two more to see if anybody has anything to type in as far as a question. But thanks to all of you who did log in and who have stayed with us to this point, as I know we're a good bit over the hour answering some of these questions, but obviously sometimes the questions provide some of the best information. If there's any further question, then you have my contact information available on the screen. You have the slides available to you. If you're registered, again, you'll get an email tomorrow with the link to get that material at any point. So you'll have that available as well. If there are no further questions coming in shortly, then I will go ahead and log off. I just appreciate all of you taking the time and look forward to having you in future webinars. We do this roughly monthly, at least say 3 out of every 4 months or something like that. We tend to have one, depending on what else is going on and what developments there are to talk about. If you have any suggestions for future webinars, then you're always welcome to contact me with those as well. So thanks for logging in again, and I don't see any more questions. So I'm going to go ahead and log off, and we will see you next time. Thanks.